Hello, everybody. It's Zach here from RealEstateLicenseWizard.com. Today, we're going over another one of our practice real estate exam questions. If you're new here, we do post a new question every Monday through Friday, so make sure to subscribe for more. If you do have any questions you want me to cover, please comment the full questions down below or send us an email with the question. Anyways, let's jump right into it. So today's question is another one that has to deal with environmental law in real estate. So the question states, used in connection with CERCLA and the creation of the Superfund, retroactive liability means, and it gives us four options. A, all previous owners are not held accountable for the hazardous waste site. B, all previous owners also can be held accountable for the hazardous waste site. C, the last two previous owners also can be held accountable for the hazardous waste site. Or D, the last three previous owners also can be held accountable for the hazardous waste site. So as always, I'm going to give you guys an opportunity to pause here, think it over, read it over, all that good stuff, and then we'll jump into the explanation. Okay, you guys all set? So the correct answer for this one is B. All previous owners also can be held accountable for the hazardous waste site. So think of it like this. Basically, when CERCLA and the Superfund and all these things were created, there was some liability for new owners, and I mentioned this actually in our last video a little bit briefly, but when the Superfund and the SARA was created, it developed this term retroactive liability, which means previous owners can be held accountable for hazardous waste sites. So if they don't disclose that, or maybe they just didn't worry about it the entire time and they sell the property, well, guess what? They can still be held accountable. And this is important because before then, there really was no sort of a sense of, what's the word I'm looking for? Uh, sense of security. Yeah, sense of security for someone who's purchasing property, because someone could purchase a property, and if they find some sort of hazardous waste on their property, that's up to them to deal with. And originally that was, and that put owners in a difficult situation. And with the creation of this, and the idea of retroactive liability, it made it so there was some sort of a safety net, almost. That's how I would describe it. So that people can purchase property, and if a year later they find out that there's hazardous waste and previous owner didn't disclose it, well, guess what? Those previous owners, they're going to be held accountable because either A, they didn't disclose it, or B, they didn't deal with it, or both. So yeah, so that's basically what retroactive liability means and kind of what its connections um, come up, and kind of like a description of all of it. But it's super important to understand, especially if you're dealing with commercial real estate, big properties where there's potential for hazardous waste and things like that. But this does come up all the time on the exam. It's I think environmental law is one of those things that, as the years progress, they're focusing more and more on, because it's super important. And as I mentioned, commercial real estate comes up all the time. So yeah, that's pretty much it for this one. I hope you guys learned something. If you guys do have any questions or comments, please leave them down below. Yeah, that's it for me today. I hope you guys have a fantastic day. As always, this is Zach from RealEstateLicenseWizard.com. Make today magical.